Good morning. I'm Gary DeWaal, and this is Bridging the Weeks from November 21st to December 2nd, and today is December 5th, 2016. Last week, the Commodity Futures Trading Commission re-proposed capital rules for swap dealers, while the European Commission proposed capital rules for EU-based banks that do not discourage bank subsidiaries from carrying cleared positions for customers, as does a prior approach taken by the Basel Committee on Banking Supervision. Additionally, the Securities and Exchange Commission weighed in to a federal appellate court in New York in favor of a legal position taken by institutional investors against securities exchanges in a lawsuit related to the supposed advantages afforded high-frequency traders. I'm still recovering from my Thanksgiving dinner and celebration, as well as all the holiday parties last week. So I can get ready for another round of parties this week. Let's get started. The Commodity Futures Trading Commission re-proposed minimum capital requirements for swap dealers and major swap participants that are not subject to prudential regulation, so-called covered entities. Under its proposal, there would be three alternative capital approaches: a bank-based capital approach, a net liquid assets capital approach, and a tangible net worth capital approach for swap dealers. The bank-based capital approach would permit swap dealers to comply with capital requirements adopted by the Board of Governors of the Federal Reserve System for bank holding companies. The net liquid assets capital approach would be consistent with the CFTC's current capital requirements for futures commission merchants, the Securities and Exchange Commission's current capital approach for broker-dealers and over-the-counter derivatives dealers, and the SEC's proposed requirements for security-based swap dealers. The tangible net worth capital approach would be available solely to a swap dealer principal engaged in non-financial activities. Non-U.S. based swap dealers could potentially comply with local capital requirements as an additional alternative if approved by the CFTC pursuant to a comparability determination. As part of its proposed capital rules, the CFTC would also require covered entities to provide it and the NFA with monthly financial statements and an annual certified financial statement, and to keep current books and records. Covered entities would also be subject to special early warning notification requirements related to material adverse changes in their financial condition, as well as a weekly obligation to report their uncleared swaps position and margin information, quote, for the purpose of conducting risk surveillance, end of quote. The CFTC previously proposed capital rules for covered entities in 2011, but deferred further action pending finalization and implementation of uncleared swaps margin requirements. The CFTC finalized margin requirements in December 2015, and they began being implemented in September 2016. Comments on the CFTC's proposed capital rules will be accepted for 90 days following their publication in the Federal Register. The CME Group adopted amendments to its current rules governing disciplinary proceedings that, among other things, increase the monetary sanctioning authority of a Business Conduct Committee panel from US $1 million to $5 million for each offense. In addition, the amendments eliminate the current authority of a respondent to a disciplinary proceeding to make a motion to dismiss prior to a formal hearing or to submit for consideration by a Business Conduct Committee panel a settlement offer unsupported by CME Group market regulation staff. The amendments also empower a Business Conduct Committee panel to order a respondent or its legal counsel or other representative to pay out-of-pocket expenses in connection with such person's, quote, vexatious, frivolous, or bad faith conduct during the course of an investigation or enforcement proceeding, end of quote, without a distinct hearing, and eliminate a BCC's panel's authority to issue a reprimand as one of many potential sanctions. Numerous other changes are also included in the CME Group's amendments that, absent objection by the Commodity Futures Trading Commission, will be effective December 14th. The European Commission proposed additional measures for EU-based banks that aim to enhance, quote-unquote, institutional resilience of the European banking system. Among the measures include imposition of a 3% leverage ratio for banks. Leverage ratio equals a bank's regulatory capital divided by total assets, including certain off-balance sheet exposures attributable to its derivatives transactions. However, the EC proposes in order, quote, not to disincentivize client clearing, end of quote, that banking institutions be permitted to offset the amount of their exposures attributable to client positions cleared through qualifying clearinghouses by client-posted initial margin. This would be different than the approach taken by the Basel Committee on Banking Supervision that does not permit such offset. And finally, the Securities and Exchange Commission argued in a brief filed in a federal appellate court located in New York that exchanges have no absolute immunity from claims filed by certain institutional investors, including the City of Providence, Rhode Island, alleging favoritism for high-frequency traders. The investors' lawsuit, initially filed in April 2014, alleged that certain exchanges, including BATS Global Markets, Chicago Stock Exchange, Direct Edge, ARCA, and others, improperly revealed price data to high-frequency traders before anyone else by making available co-location services, proprietary data feeds, and certain complex order types, and that this constituted market manipulation in violation of applicable securities law and rule of the Securities and Exchange Commission. The district court previously dismissed all charges against the exchanges, claiming that plaintiffs' complaints failed to state a claim of action and that their provision of data feeds in different order types was barred by the doctrine of absolute immunity. The SEC argued that while exchanges should be afforded absolute immunity when they act in their traditional self-regulatory function, the doctrine should not extend, quote, to functions performed by an exchange itself in the operation of its own market or to the sale of products and services arising out of those functions, like the challenge activities at the center of the plaintiff's allegations, end of quote. Well, that's it for this week's edition of Bridging the Week. As always, there's more information in each article and more articles on the article version of Bridging the Week on the website. Check it out. I'm Gary DeWaal. Have a great week, and until the next edition of Bridging the Week, ciao, and be mindful of what you eat or how much this week.